In Canadian immigration, there are two types of criminality. The first type of criminality is simply called criminality or sometimes general criminality. The general criminality ground only applies to and impacts foreign nationals. For example, people living in Canada on student visas, temporary work permits, visitor visas, etc. Permanent residents of Canada are not inadmissible under general criminality grounds, so they don't need to worry about this. Foreign nationals can be inadmissible for general criminality under four circumstances. First, they were convicted in Canada of an offense punishable by way of indictment, or of any two offenses under any act of Parliament not arising out of a single occurrence. Second, they were convicted outside of Canada of an offense that, if it were committed in Canada, would constitute an indictable offense, or of two offenses not arising out of a single occurrence that would constitute offenses under an act of Parliament. Third, they committed an act outside of Canada that's an offense in the place where it was committed, and that, if it was committed in Canada, would constitute an indictable offense. Or four, if they committed on entering Canada an offense under an act of Parliament prescribed by regulations. Okay, that was a lot, very dense. Let's break it down. In our last video, we discussed what an indictable offense is. To refresh your memory, it's the most serious type of offense in Canada. Very, very similar to a US felony. Now, here's an interesting sticking point. Most of the offenses within the Criminal Code of Canada are actually hybrid offenses, not indictable offenses. For purposes of criminal inadmissibility, though, all hybrid offenses are deemed to be indictable offenses, even if the Crown prosecutes it summarily. All references to an act of Parliament means that only offenses arising from federal legislation will result in inadmissibility. If it's an offense under a provincial statute, such as offenses under the Ontario Highway Traffic Act, it won't cause inadmissibility. Additionally, offenses under a few specific pieces of federal legislation are excluded from any inadmissibility analysis. Specifically, that means offenses under the Contraventions Act, convictions under the Youth Criminal Justice Act, and convictions under the former Young Offenders Act aren't going to be considered inadmissibility. So depending on how closely you're listening, you might have noticed that the four grounds of general criminality distinguish between convictions and committing an offense. Whenever there's a reference to a conviction, it means that an actual conviction must occur before inadmissibility will result. Being charged with a crime is not the same thing as being convicted, and any disposition that does not result in a conviction will not cause a person to be inadmissible for immigration purposes. When charges are laid, officers are to wait for the disposition of those charges before alleging inadmissibility. A disposition is kind of like a final outcome of the case. A conviction is one of the possible outcomes, but it's often not the only one available. For example, an absolute or conditional discharge is not considered a conviction. Additionally, peace bonds, which is basically the Canadian version of a restraining order where we promise to keep the peace, is not a conviction and therefore will not result in inadmissibility. As you'll recall from our last video, summary offenses are a lot like the US misdemeanor. They're generally non-violent offenses that often result in minimal or no jail time. A single summary conviction does not make a person inadmissible. However, two or more summary convictions arising out of different occurrences will result in inadmissibility based on general criminality. This means that if a person is charged and convicted of two summary offenses resulting from the same event, so maybe theft under $5,000 and damage to property resulting from one crazy night out, they're not criminally inadmissible. However, if they're convicted of theft under $5,000 for something they did in December, and then they're later convicted of an offense for property damage for something they did in January, then they would be considered criminally inadmissible. Here's another example. Let's talk about Mike. Mike is a college student in his junior year at a school in Michigan. Mike's just completed his final exams and he goes to a big off-campus party to celebrate. Mike's a little drunk. He ends up getting in a fist fight. The cops are called in to break up the fight and to break up the party, and Mike ultimately gets charged with misdemeanor assault and convicted. A few months later, Mike was drinking again, and ends up smashing the windows of a parked car. He pleads guilty to willful and malicious destruction of property. Mike then graduates from college a few months later and proposes to his girlfriend. Once they're married, Mike's wife, who happens to be Canadian, sponsors him for permanent residence. The only problem? Mike is now criminally inadmissible. He can't be sponsored until significantly more time has passed, enough to be deemed rehabilitated, or until he sorts out options available with an immigration lawyer. If you have any questions about this, please feel free to reach out to us at www.sisulegal.com and stay tuned for our next video on serious criminality.